This is the matter of Gabriella Hall, file J26-397-NA.
Don Sommerfeld for the Department of Health and Human Services.
I do see Ms. Matthias from the department is with us as well. This is the first hearing on an emergency take and place order that was done last night in regard to Gabriella. Ms. Matthias, could you inform the court of what transpired from last night to this morning?
From last night, yes, we went down and picked Gabriella up from Cedar Creek Hospital, and we brought her here to, she actually was in a treatment foster home for one night. They had availability for one night. And so she went to a treatment foster home in Kalkaska last night. And we are working on placement moving forward from here.
All right. Before we came on the record, I asked you about notice to mom. If you could tell me what, if any, contact you've had with the mother and what attempts at notice, if any, you've made.
So we've had contact with mother throughout this process. She's aware of the petition being filed. We had brief contact with her by phone this morning. She was traveling out of state, their family emergency with her mother. So she was traveling out of state. We did have contact with her regarding Gabriella's medications and had her sign a form that was needed for that. So she was aware, but I don't believe at that time when we had contact with her that we knew what time the hearing was today. We can certainly provide her notices of hearing moving forward, and I would not anticipate any issue with her participating in future court hearings.
All right, thank you.
Judge, can I make a record about this?
Absolutely.
Yes. This is a very unique gray area in the law. And I say that because there's a Supreme Court case that came down April 14th, 2025. It's called In the Matter of Lang. It's DVL and then LANGE. It has a Supreme Court number of 166509. I'm not sure if they have a citation just yet. That'll get you to the right place. What happened in that case is so similar to the facts in these cases. And I'll explain what happened in that case is that the child, much like in our case, had severe mental and emotional problems, hospitalized, CMH, just a history of violence, much like that is alleged in our petition for Gabriella, I'm sorry. And what happened is that the same situation occurred. The child was in a secure environment. Like in our case, it was that listening ear. It was listening ear foster home through community mental health. And much like in the DVL Lang case, there was going to be a discharge and a date. And what happened in the Lang case was that mom, based upon the history of, the child was very violent. Just there had been so many instances of physical, emotional, and mental abuse that she said, I can't do this. I can't, we've been taking our child to different places to get her help. And then they're like, well, the child's fine. And then you can come and take her. And it's like, I can't do this because I fear for my own safety. It's very similar almost identical to the facts in our case. Well, what happened in the Lang case is that there was a petition filed, and the trial court denied the petition based on the removal statutes of MCL 712A 2B1 and 2B2. Those are the normal ones that we generally use. Those are the parent or other person legally responsible for the care and maintenance of the children. And this is important when able to do so. Neglected or refused to provide proper and necessary support, education as it goes on, or other care necessary. And then the home or environment by reason of neglect, cruelty, drunkenness, criminality, and depravity makes, it's an unfit home. The trial court in Lang said none of those statutes applied and denied the authorization of the petition. What happened is that the department went to the Court of Appeals and then in a split decision said that both of those statutory grounds, MCL 712A 2B1 and 2B2, that they both applied. There was an appeal to the Supreme Court, and then opinion was issued April 14th of 2025, and they concluded the trial court did not clearly err by refusing to take jurisdiction of DVL under MCL 712A.2B1 or 2 because respondent mother was not able to provide necessary care or support for DVL at home, and her treatment of DVL was not neglectful, and that would have been under 2B2. What they went to further define that when we look at the term in the statute of 2B1, when able to do so, able may be defined as having sufficient power, skill, or resources to do something. And what they said is that respondent did not have sufficient power, skill, or resources. They also made a similar finding that there was no neglect by mom. And the Court of Appeals decision was reversed, and the case was remanded back to the trial court for reinstatement. This was not a unanimous decision from the Supreme Court. There were other justices that concurred, but said, Justice Kavanaugh said the available grounds for jurisdiction were ill-equipped to address situations involving children with serious mental health diagnosis, and he appealed to the legislature to fix this gap. There was also Justice Bernstein. He was concurring in part and dissenting in part. And this, I just want to make a record of this, but when he looked at the issue here, that there was a case, it was in the matter of Jacobs, and that had a definition of neglect. It was later codified by statute. And so Jacobs is no longer good law as it relates to culpability under 2B2. And it says, he stated, by failing to decide whether Jacobs remained good law after the statute was amended, the majority opinion failed to provide adequate guidance to the courts applying the neglect and abuse statutory grounds for jurisdiction. Specifically, he noted MCL 712A 2B2. And then there was a dissenting opinion by Justice Zahara. The majority concluded that there was a proper avenue under the existing law that a child would be homeless when a parent was unable, not having that, that skill, power, or resources to do something for the benefit of the child. That's where we sit today. This is a very unusual situation. Personally, in the last 22 years, I've had 1 or 2 delinquency petitions. So we could not file a petition based on the normal statutory grounds for removal where mom would be a respondent. It's still unclear looking at this opinion, would mom be a respondent? All of this, none of this has been decided. However, based upon the needs of the child and to protect the child, the life, physical health and mental well-being, based on the CPS complaint, the department had to bring this to the attention of the court and did so through a petition for delinquency because of the Supreme Court case. I don't know of any other recourse at this point, and this is where we sit today. Thank you.
Thank you, Mr. Sommerfeld. I do appreciate the fine line that you've drawn and the information from the Lang case. Now that you've mentioned it again, I do recall that case, having read it when it first came out. My view of the matter, as I saw it on an emergency basis last night, was that we have a child that has some severe mental health and behavioral issues that was in essence going to be placed in an untenable position of having no place to go and no one to care for it. And I thought it would be best to err on the side of safety and appropriate placed custody with DHHS, to err on that side and allow the facts to be fleshed out in the future as to where we go with this case. But in the meantime, she would at least have a safe place to stay while we do sort out those issues. So I appreciate you putting that on the record. We'll use that in the future, I'm sure. Right now, because no one is present to have me read information to them or rights to them or petition to them, I'm simply going to appoint counsel for mom. I'm going to ask MDHHS to give notice to mom for our next hearing. And I'm going to ask that a continued preliminary hearing be set so that we can have mom here and she can participate, whether that be as a non-respondent in a delinquency matter or whether that be as a respondent in a child protective services matter. I'll let us sort that out in the future with the help of assistance of counsel for both sides. Is there anything else that you believe that we need to do today, Mr. Sommerfeld?
No, normally we have the 5 questions about removal. The petition on its face was not, does not indicate a removal for mom, just that a child was homeless due to these circumstances, and then the uncertainty in the law. And much like the court, the department filed a case because, we had to do something here. And yeah, I know it was done with, we're traveling into rough seas maybe because of the uncertainty from the Supreme Court in this case. However, I appreciate that the court erred on the side of protecting the child because I think it was clearly warranted.
All right. Well, and you bring up a good point. Maybe it would be appropriate for me to at least make a small record with Ms. Mathias as a witness as to the removal factors, just in case there is some appeal in the future. So Ms. Mathias, would you raise your right hand so I can swear you in? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, you do.
Mr. Sommerfeld, do you want to ask those questions or do you want me to do that?
Yeah, I'm very familiar with petition and I've spoke with Ms. Mathias last night. So do I have the floor, Judge?
Yes.
Thank you. Ms. Mathias, can you state your name, please, and spell your last name?
Lisa Mathias, Mathias.
And how are you employed?
I'm a Children's Protective Services Supervisor for Department of Health and Human Services in Otsego County.
Okay, and we're here on a petition regarding a minor child, Gabriella Hall. Are you familiar with that?
Yes.
And who is the mother of Gabriella?
Holly Enox.
Okay, and what county does she reside?
Otsego County.
Okay, and Gabriella's father, is he in the picture?
He is not, his rights have been terminated is what we've been told. We are looking for confirmation of that. It is out of Missouri. He is currently incarcerated in Missouri.
All right. And Gabriella, she is under 18 years old and would fall under the child protection law of the state of Michigan.
Correct.
All right, thank you. The petition alleges that the minor child has significant mental health issues. Can you speak to that?
Yes, her most recent diagnosis at Cedar Creek was autism spectrum disorder, PTSD, dissociated features, ADHD combined, DMDD, anxiety, depression, and clinical features of BPD.
All right, and has there been issues that Gabriella has made that could potentially that she would harm herself or others?
Yes, she has had ongoing homicidal ideations and suicidal ideations.
All right, and the mom, she has tried to, get services to address the issues of her minor child.
Correct.
All right, and so the petition alleges that these services have been going on for a period of 5 years.
Yes, 5 years locally. That's how long the family's been in this general area. So that is the history of services that I am most familiar with.
Okay, and through several placements, she was ultimately last night or the day before that at a listening ear foster home through community mental health.
Well, yes, but the timeline that you offered earlier is slightly off. I can clarify that.
Sure.
Gabriella had been it started in an emergency room approximately 6 months ago, and then she was in a residential treatment program, and then was placed in the foster home, listening ear foster home, through CMH. There was no abuse neglect petition or anything, but it was through CMH. She was placed in that home. She was there for approximately 2 months. She began having homicidal ideations while in the home. She went from there to an emergency department of a local hospital. From there, she went to Cedar Creek, which was the short-term psychiatric hospital. And at that point, they deemed her medically cleared for discharge. And so that is when we got involved, was when she was medically cleared at Cedar Creek. The listening ear foster home was unable to take her back into the home because of the safety concerns and the homicidal ideations.
All right. And then also in the petition, sometime on or about sometime fall of 2025, was there some type of what could be described as a violent incident between Gabriella and her mother?
Yes, Gabriella attacked her mother physically while they were at community mental health in the lobby.
Okay, and did mom receive injuries? Can you tell us what specifically happened?
Yes, Gabriella slammed or pushed her mom's head into the brick or cement wall and caused a concussion.
So the department received a CPS complaint on 4/1 of 2026. Is that correct?
Correct.
Can you tell us about that?
The complaint simply indicated that Gabriella was ready for medical discharge and her mother was unwilling to pick her up from the hospital.
Okay. And have you had conversations with Holly Enochs, the mother?
Yes, several recently, but also over a period of time.
Okay. And she, I don't want to put words in your mouth, but has she described that she does not have the She does not have the sufficient power, skill, or resources to provide the care necessary to her daughter.
Yes, at this time, Gabriella is still expressing that if she is with her mother, she will harm her. And Holly does not have any ability to change that, protect herself from that, or alter Gabriella's sort of state of mind, I guess it is, towards her mother, despite Holly's continuing to be involved in Gabriella's treatment and wanting appropriate treatment for her. But she does not have the ability to keep herself and or Gabriella safe in the home.
All right, and we're what you've described, the kind of the timeline of the child and mom's interactions, and the services that Gabriella has attended, would those qualify as reasonable efforts to not file a petition?
Yes, they would.
Okay, and so in right now, not necessarily talking about contrary to welfare, but the department, I made representations to the court that the department had, real issues about, Gabriella's, her life, her health, her physical well-being based upon her mental state and her demonstrated conduct. Was that a correct statement of the department's position?
Correct.
And that's why we filed a petition.
Correct.
All right. Thank you, Judge. I have nothing further from Ms. Mathias from me.
All right. Thank you, Ms. Mathias. I do find that returning Gabriella to the home through really no fault of Ms. Enochs, the mom, would represent a substantial risk of harm to the child. At least her mental health, if not her physical or and emotional well-being as well, given that she has expressed homicidal ideation towards mom. I do find that there's no other service or other arrangements which would safeguard the child from that substantial risk of harm other than placement with the MDHHS as was done last night. I do find that returning the child to the home would be contrary to the child's welfare for the reasons I expressed above. I do find that reasonable efforts were made to prevent or eliminate the need by foster care and CMH involvement, emergency room involvement, and CPS investigations. And that the conditions away from the parent are adequate to safeguard the child's health and welfare because it removes the threat to the mother and the threat of emotional harm to the child. For those reasons, I do find it was appropriate to place the child last night, and we'll continue that placement until we can have future hearings. The court will set a future hearing date for continuation of the preliminary examination. Will authorize attorney to represent the child and also to represent the mother, and we'll have a further hearing as soon as possible. Anything else for today, Mr. Sommerfeld?
No, and thank you very much, Judge.
Ms. Mathias, anything else?
No, thank you.
Thank you for your assistance to both last night and today. That'll be all for today. We'll be in recess.